half over.
And I don't have an email. I want to start, I watched you for the last couple of days, Judge, and I want to compliment you on your demeanor. And I mean that. I know you're on your best behavior, but I appreciate your humility. We both know some federal judges who can pretty much strut sitting down. And I appreciate your attitude and your demeanor, and I mean that.
Thank you very much, Senator.
I just want to ask you a few questions about the law. I'm not going to ask you to violate the canon of judicial ethics. I'm not asking you to go thumbs up or thumbs down. I'm truly not. I may have to interrupt you a few times just to move us along. I'm not trying to be rude. I want you to understand that.
Sir.
You know, you have been nominated for the most powerful, unelected position in the most powerful country in all of human history. Congratulations, but you understand also where we're coming from. There's no margin for error.
Yes, sir.
We've got to get this right. Yesterday, gentlemen, take it outside, would you? Yesterday, I talked a little bit about the fact that judges have limits on their power. And I don't know if I said it this way, but I said I think it's inappropriate for a federal judge to try to rewrite the Constitution every other Thursday to advance an agenda that either he or her supporters can't get by the voters. You agree with that?
Yes, of course, Senator. The judges interpret the law. They don't make the law, and that's obviously something that's repeated a lot, almost cliche, but it actually matters. If you keep that in mind, it matters.
Judges also have another duty, though. I didn't get to talk about it yesterday. Federal judges and state court judges have an obligation to protect inalienable rights, even if the majority wants to take them away. That's why they call them inalienable. And I said this when Judge Gorsuch was here. If you think about it, in many cases, the Bill of Rights is really not there for the high school quarterback or the prom queen. The Bill of Rights is there for the person who kind of sees the world differently, but has the right to do that. And I think that's important for a judge. Can we agree on that?
Absolutely, Senator. I think the Bill of Rights protects all of us, but that includes, and it's most relevant for free speech of the unpopular or the unpopular criminal defense.
Even if the majority says,
yes,
we're the majority, because we both know that sometimes the majority just means that most of the fools are on the same side. I mean, just because you're the majority doesn't mean you're right. Correct?
Just because you're in the majority does not mean you're right is absolutely a correct proposition.
Right. That's why we have a Bill of Rights.
Yes.
All right, I want to talk about, now that's the easy part. I want to talk about how we go about making these decisions, and there's a tension there, and that has to do with the language. If I talk about, and you've talked about it a little bit, but if I talked about the Holy Trinity doctrine, you'd know what I'm talking about, I'm sure.
Yes.
Okay. Now, the Supreme Court has rejected the Holy Trinity doctrine.
Right.
Okay.
Yes.
You talked about we're now textualists and are originalists, and you call the originalism constitutional textualism, I think.
Original public meaning,
right.
Originalism, constitutional textualism. I think those describe the same thing.
Okay. You start with the language. Let's take a statute, with the language in the statute.
Yes, sir.
And the first question you ask as a textualist, is it ambiguous or unambiguous? Correct?
if there's a canon of construction that is there that depends on a finding of ambiguity, that would be the question. Otherwise, other than that, you would just see what's the best meaning.
You read the statute.
Yes, read
and
the
say,
statute.
does it make sense? It either makes sense or it doesn't.
Yeah.
How do you determine that? How ambiguous? You alluded to this, but how ambiguous does it have to be? Does it have to be 100% ambiguous?
Right.
Does it have to be 51% ambiguous? Is there really any principled way to compare clarity to ambiguity? Or do some judges use it as an excuse to get to those canons of interpretation about which they've already read in the brief to do what they want to do? Did you know?
Yes. So I've said many times in my cases and talks to students that judges shouldn't be snatching ambiguity from clarity. So that's one thing. I think that goes right to your question. But to your broader question is, that's one of my concerns about a few canons of construction that depend on an initial finding of ambiguity, which sounds great in theory, which is, oh, if it's ambiguous, go to that canon or this canon or this canon. But in practice, over 12 years, what I've found, and I've written about this, is that there's not a good way to find neutral principles on which two, or in my case, three judges can agree on how ambiguous is ambiguity. And that's hard to even talk about with you. Oh, I find it ambiguous. I don't think it's ambiguous. And that is, in my view, frustrated the goal that I have of the judge's umpire, the even-handed application of neutral principles in the rule of law. And ultimately, that's concerned me because some of these cases where that's come up are big deal cases, yet it's dependent on this initial determination that when you unpack it and you actually sit in the judicial conference room like I do, it turns out to be very hard to apply in an even-handed way. So that's been the concern I've identified.
I read your review article.
Yes.
You advocate the best reading of the statute.
Mm-hmm.
Okay.
Yes.
Okay, let's talk about that. And I want to talk about it not in terms of the statute, but the Second Amendment, and talk about the Heller case. Mm-hmm. You defined originalism as constitutional textualism, and the way to interpret the Constitution is to ask yourself. Tell me if I get this wrong now. Mm-hmm. How would a reasonable person at that time have understood the Constitution? The public knowledge.
The original public meaning. I always want to add, of course, precedent is a huge part of what we do in constitutional law, but if you're looking at the words, the original public meaning, you look at what the words mean. Sometimes the meaning's changed, oftentimes it hasn't, but to your point, I agree.
And it's almost an objective test.
You're trying to make it as objective as possible, absolutely. It is an objective test. Yes. I mean, sometimes there's different evidence about what the meaning of the word was, I think.
Sure, but you're not looking at intent.
Correct. You're not looking at the subjective intent other than to the extent that helps show the
meaning. We've thrown that out.
Yes.
Okay, if you look at the Heller case, and I'm talking about the D.C. v. Heller by the U.S. Supreme Court, it wasn't a balancing case. Mm-hmm. You made that point clear at the Court of Appeal level. It was a text, history, and tradition case. Mm-hmm. And Justice Scalia wrote the majority opinion. Justice Stevens dissented, and they both took an originalist approach. And I went back and looked. Scalia, this is what he relied on. He relied on founding-era dictionaries, founding-era treatises. He looked at English laws, American colonial laws, British and American historical documents, colonial-era state constitutions. He looked at post-enactment commentary on the Second Amendment. And Justice Stevens, also using an originalist approach, looked at the same documents, and then he relied on linguistic professors, an 18th century treatise on synonymous words, and a different edition of the colonial era dictionary that Justice Scalia used. Pretty impressive. Here's my question. Doesn't the originalist approach just require a judge to be an historian? And an untrained historian at that?
I don't think...
wouldn't we be better off hiring a trained historian to go back and look at all of this commentary?
Well, the Hoefler case was one of the rare cases where the Supreme Court was deciding the meaning of a constitutional provision without the benefit of much, if any, relevant precedent. On most of the constitutional provisions, there's been a body of cases over time interpreting the provision, and you don't have to do the kind of excavation that Justice Scalia and Justice Stevens did in that case because it's been done before. The reason I think why the Second Amendment posed a challenge in that case in terms of figuring it out is the prefatory clause in the Second Amendment, which the question was did that define the scope of the right indicated afterwards, the right of the people to keep and bear arms shall not be infringed, or did the prefatory clause merely state a purpose for which the right was ratified, and therefore you read the right as written, the right to keep and bear arms shall not be infringed. And to figure out what the prefatory clause meant, you had to figure out as a general proposition how legal documents at the time used prefatory clauses and what the purposes of those were, and that required a lot of historical excavation by the two justices who had the competing positions.
Okay, fair enough. Somebody commented yesterday, maybe it was you, Judge, they talked about how our judiciary was one of the crowning jewels of our government, and the fact that it separates us from other countries.
Yes.
I think one of the reasons so many of our neighbors in the world want to come here is because of our independent judiciary. They know their person, their property will be protected. I think that singles us out. You know, you never read about somebody trying to sneak into China. They want to come to America. But there have also been studies, I think Senator Booker talked about this, maybe it was Senator Whitehouse. People have, in America, many of them think the United States Supreme Court is a little Congress, that it's political. And that's unfortunate because that means we lose confidence in an independent judiciary. I'm not saying it's true, but perception is important in government. Do you think having cameras in the courtroom would help?
Senator, that's an issue that I've thought about. And let me just give you a little perspective on our court. We've gone to same-time audio in our court. We started with release of tapes much later, then release of tapes later in the week, then release of tapes later in the day, and now we're same-time audio in our court. And I think that's been that's worked at the Court of Appeals level for us. I know nominees who've sat in this chair in the past have expressed the desire for cameras in the courtroom only to get to the Supreme Court and really change their positions fairly rapidly. So that gives me some humility about making confident assertions about that. And of course, joining a team of 9 means thinking about that if I were fortunate enough to do so, in hearing the perspectives of why did they change their position, what's their view. I will say one thing about that I do think is important. Oral arguments are a time for the judges to ask testing questions of both sides, and there's a perception sometimes, and you see it in the media, that the oral argument, Judge X is leaning this way at oral argument. I really can't stand that kind of commentary about oral argument because at least have always approached oral argument as the time to ask tough questions of both sides, and I do sometimes wonder whether people would get the wrong impression of oral argument. Now, I've always thought, too, though, the announcement of the Supreme Court decisions, when they issue the opinions, that's a different point in time when if there...
What did you say Justice Marshall said? People aren't fools? Well, you have to trust the people sometimes, Judge.
And as to the decisions, right, that's when the court is announcing its decision, and that is the decision of the court. Oral argument lawyers people are asking tough questions of both sides, and sometimes you would think, oh, Judge X thinks this because of the oral argument question.
I understand.
But the decisions, I think let's put it this way, if I were starting, I think I'll stop there.
Well, I get your point, and they're good arguments on both sides, but I do think that the American people have lost confidence in the institution of the Supreme Court and Congress and the presidency. And it's ironic, given my generation, that the only institution that the American people I think have a lot of confidence in right now is the military, which wasn't true in my era.
Well, that shows.
But you know, you got to trust the people, and too many up here in the Beltway don't.
I agree with your general.
You know, they don't. The people don't read Aristotle every day, but they get it. They'll figure it out. All right, let me ask you a couple more. You're an originalist.
Did I pay attention? Yes, I pay attention to the text, the original public meaning, but informed. I always want to make sure I say precedent. If you're in a constitutional case, precedent is critically important, and that's part of the text of the Constitution.
Right, but the focus of primarily of an originalist is an understanding of the Constitution by the people, an objective test at the time it was written and ratified.
The meaning as opposed to the intent, and then informed.
Right.
I always have to add precedent.
I get it. I'm not trying to trick you.
No, I understand.
I couldn't trick you.
I just want to be clear in case someone takes something out of context.
All right. Are you willing to overturn precedent that you think conflicts with the original public understanding of the document?
The Supreme Court's rules on precedent, the precedent on precedent, sets forth a series of conditions that you look for before you consider whether to overrule.
But I'm just asking you, if you come upon a case and you say, you know, I'm on the Supreme Court now, and I've looked at this, and that's not under originalism. That's not what the public understanding was.
So the first inquiry is the prior decision wrong, actually grievously wrong? And if you thought it was grievously wrong, that would be, you'd go on to because of that or for some other reason, you'd go on to the next steps of the stare decisis inquiry, but that's how that would work, if I understand the question correctly.
Okay. All right. Can we agree that there were state constitutions that preceded the federal Constitution?
They did, and the framers at Philadelphia drew on a lot of the experience of the state constitution.
They drew from state constitutions.
Sure did.
Yeah. And can we agree that every state now has a state constitution?
Yes, and they protect a lot of rights.
Yep. In fact, before the federal Constitution was extended to the states through the 14th Amendment, the only protection you had from state government was a state constitution.
That's correct, other than the rights articulated in Article 1, Section 10 of the original Constitution, yes. Ex post facto.
Can we agree that you're right under the U.S. Constitution? Let's take the Bill of Rights, but you know what I mean the whole document. Let's take the First Amendment. Can we agree that the First Amendment in the United States Constitution sets the floor, that the state counterpart, the state First Amendment counterpart, can actually give you a greater First Amendment right?
Correct, and I think I've mentioned a couple times Judge Sutton's book, and Justice Brennan wrote an article in the 1970s about state constitutional law doing exactly what you said and encouraging state litigants in state courts and state court judges to think about exactly what you're saying.
Well, and in fact, some states have. Like California, for example, their First Amendment, they don't have a state action requirement. Mm-hmm. Am I correct in that?
I will admit I haven't looked at the California Constitution recently, but I'll take your understanding of it, Senator.
Well, they don't. Yeah. In a private shopping center, so long as it's a common area, somebody can go in there and protest, and you have a First Amendment right under the state constitution.
And the only question in that case would be if it conflicts with another provision of the federal Constitution.
And that's my question.
Okay.
That's my question. What happens when a state interprets its own First Amendment, which it can insulate from review by you guys, or by you soon-to-be guys on the Supreme Court, under the adequate and independent state ground doctrine, but it conflicts with your Fifth Amendment property right?
Well, Article 6 of the Constitution makes clear that the federal Constitution is the supreme law of the land, and that trumps not only state legislation, but also state constitutional decisions. So in that instance, the property right protected, if it were determined that what you're talking about violated the property right in the U.S. Constitution, that would control.
Except that's not what the United States Supreme Court said in the Pruneyard case.
Well, there was it was a balance. I think because they interpreted the property right not to be affected. But California won. Yeah, but the point being, and I think I had the premise, I hope I did in what I said to you, if you concluded that it violated the property protection in the U.S. Constitution, then the U.S. Constitution would control. In that case, the Supreme Court concluded that it did not violate the property protection of the U.S. Constitution.
I know I couldn't outsmart you. You're right. All right, you've got this First Amendment property, or this First Amendment speech right, free speech right on steroids in California. And there's no state action requirement. In Golden Gateway, Pruneyard, all you know, they all said it applies to a private entity, like a shopping center. I know that Justice Kennedy, I don't have the language here, but he's talked about how the internet is the new public arena. Okay. If you have, and other states have adopted this approach, same as California, this enhanced First Amendment right with no state action requirement. I think New Jersey has, and there's some other cases. How then can Twitter in California censor any messages? If you're living in California and you have a First Amendment right and it's not limited by the state action doctrine.
Senator, that sounds like a hypothetical I am not prepared to give you a full answer on, other than I'll give you a broader conception of.
Well, it's coming.
Right. So I think one of the things with these proceedings for judges and Supreme Court justice nominee hearings are backward looking in terms of our cases, the cases I've done and the cases the Supreme Court's decided. But one of the interesting things that I think about is what's the future? What are the big issues coming down the pike? And
that's
so
one of them.
Speech, how technology affects our conception of speech, how technology affects Fourth Amendment rights and our conception of search and seizure and privacy. I think on the war powers front, which I was discussing with Senator Sass and Senator Flake earlier, cyber war and how does the war powers framework fit in with cyber attacks? And I think those are three things, all technology rooted, that someone sitting in this seat 10 years from now are going to be, I think, critical issues. And I think we also think, again, backward looking, but what are the future crisis moments? Because there will be crisis moments for the Supreme Court, and usually those are unpredictable. When Justice Ginsburg and Breyer went through, you wouldn't have predicted September 11th, for example, or even thought to ask them questions about.
I'll stop you, Judge. I'm going to run out of time.
Thank you, sir.
I want to talk about Chevron deference just for a second. Here's my understanding of Chevron, the deference. First of all, the statute's got to be ambiguous. And if it is ambiguous, according to our Supreme Court, we've got to adopt the agency interpretation, even if it's not the most reasonable interpretation.
That's right.
It's just got to be halfway reasonable.
They say reasonable, but even your point was it's not the most reasonable.
It's not the most reasonable, okay? Here's what I don't understand. You look at the APA. This is what the APA says. I'm going to quote, "The reviewing court, not the agency, the reviewing court shall decide all relevant questions of law, interpret constitutional and statutory provisions, and determine the meaning or applicability of the terms of an agency action." There it is, big as Dallas. Now, that's just the court. How come we have to defer to a federal agency under 5 U.S.C. Section 706?
So, Senator, in my article that I wrote in the Harvard Law Review on this, I pointed out that statutory provision and did say that Chevron was in tension. I think I used something stronger with that statutory provision, but Chevron concluded what it concluded, and it's been applied over time. Now, I've pointed out some problems with it in terms of its practical application, the ambiguity trigger, and you're pointing out a problem at the core, which is where did it come from to begin with, given what the APA...
Well, not only that, Judge, but I mean, I know you know this, but it encourages misbehavior. And let's suppose Senator Whitehouse or Senator Lee, they run for president. You know, they're not going to go out and run on their good looks. Well, they're good-looking guys and all that, but they're going to run on policy. And then they get elected, and they meet us in Congress. And a lot of times they can't get their bills passed.
That's right.
So you know what they do.
Yes.
They go to one of their agencies, and they say, I'm going to take my policy, square peg, and put it in a round hole of a statute. And all we've got to do is find a judge to say that the statute's ambiguous, and then we can do anything we want to do. And that's not right, is it?
Senator, that's a problem I've identified in the real-world application of certain broad conceptions of deference, and that it's a judicially orchestrated shift of power from the legislative branch to the executive branch. And the phenomenon that you've described, I think, is exactly right. Presidents run for office. I've seen this when the president I work for, President Bush.
They all do it.
And that you get, and if you can't get legislation through, then you try to see existing statutory authorities where you can achieve, to the extent possible, your policy ends, and then you push the envelope on the theory of, well, there's ambiguity in the old statute, and then sometimes courts will uphold it, and that's...
Yeah, but your hands are tied when it comes in front of you. If a president does that, and all presidents have done it, I'm not blaming them. I mean, they all do it. But your hands are tied if the statute's ambiguous, and even if the agency interpretation is not the most reasonable, it can be the 10th most reasonable, and you've got to go with it.
So two things on that. One is if the statute's ambiguous, as we discussed, turns out to be a much more difficult inquiry. Footnote 9 of Chevron does say use all the tools of statutory interpretation before you get to that, and that's something I've cited that, you know, dozens and dozens of times, that footnote, to make sure that you're not jumping too quick to deferring to the agency.
Yes, sir.
Interpretation. The other thing is the major questions, major rules.
Could you tell me quickly? I got 2 minutes.
Yes, that means if it's a particular of major economic or social significance, you shouldn't defer to the agency because that's a big deal for Congress. And
I want to ask your opinion about universal injunctions. I don't know how many federal judges, district judges we have. 700. Anybody know? 700. As I understand a nationwide injunction, sometimes they call it universal. It means that a single federal district judge can enjoin or freeze a law or a regulation. Let's suppose we have 700 federal district court judges. One of them can enjoin a law or a regulation.
This hearing is a sham. Be a hero, shut it down. Be a hero, shut it down. Vote no. This hearing is a sham.
Thank you, ma'am. I just got an extra 20 seconds under the rule. Anybody else want to go? I'll get up to 40. I'm giving myself an extra 20 seconds. Where was I? Oh, yeah, the nationwide injunction. One federal judge can enjoin a law or a regulation for the entire country, even if every other judge in the country says, I don't agree. Now, what's the legal basis for that? It's got to either be a statute or the Constitution.
Senator, that is an issue that is being contested currently in courts around the country, I think, and is an issue of debate, and therefore I think I better say nothing about it. I apologize for that, but it is an issue of current debate.
All right.
I apologize.
It's okay. I've got 9 seconds. No, I've got 29 seconds. All right, this is not meant to be a trick question. This question's not about Title IX, and it's not about sexual assault, because I know you can't answer that. But it's really well, I'm not going to ask that. I'm going to strike it. State action. Is a private security guard a state actor?
Well, as your question stated that way, the answer would be no, but I think sometimes the cases,
Couldn't be.
when if you're,
Okay, I'm gonna take the note.
there are questions of contracting, and if you're a state contractor and this and that, there are lots of
Here's my question, because I don't want to abuse this. I've always wondered this. If a city privatizes its entire police force,
Right.
they're private police officers. Do they have to comply with the Constitution?
Well, that's why I pointed out the contracting issue that I mentioned. Some of the Supreme Court case law would say you look at the contracting issue, and I think that's an interesting question that's hard to answer in the abstract without looking at the particular arrangement of the particular